Hi, I'm Shannon Miller with the Miller Elder Law Firm, and I want to talk about the essentials of estate planning. People always ask me, like, what if I only have retirement assets, a home, some investments, and maybe checking accounts? Do I really need a trust-based plan? You might. I'm not going to go into the details of how to distinguish a will-based need versus a trust-based need today, but just suffice it to say you need one of those because you don't want your assets to pass intestate, which is meaning that the state of Florida will decide who gets your money when you die. So you already have a plan. The question is, do you agree with it? So getting a will or a trust will help you with that issue. You also need a durable power of attorney. 80% of people will become incapacitated before they die if they've reached the age of 70. Having a durable power of attorney is probably the most important estate planning tool that I believe we use so commonly. Also, you need a designation of healthcare surrogate and a living will, not just for making medical decisions if you can't, but also for helping you get qualified for hospice and dealing with end of life, reducing suffering at the end of your life. In addition, a pre-need consent against exploitation is really important because we know 1 in 5 people will become exploited in the next year, who are over the age of 70. 1 in 5 over the next year will become scammed or exploited if you're over the age of 70. And then finally, an enhanced life estate deed, which is a pay on death deed, usually for your homestead or other assets, real property. And it disposes of your death, transferring it to your remainder beneficiaries just by the filing of a death certificate. So you avoid the probate process altogether with homestead and other real estate. It also keeps you qualified for Medicaid if that's something that you need in the future. We can help with these planning tools. Contact us at the Miller Elder Law Firm.